Okay, let's continue. We go to the second ground of the void marriage. The second ground, below the prescribed age. A male person marries under 18 years of age, or a female person who is 16 or above but under 18 years old marries without a special license granted by the Chief Minister under Section 10 of the LRA. The third ground is within prohibited degrees of relationship. The parties are within the prohibited degrees of relationship unless the Chief Minister grants a special license under Section 11, subsection 6 of the LRA. Next, the fourth one is the parties are not respectively male and female. The case to be referred to is height and height. The principle in this case is marriage is permanent relationship between a man and a woman to the exclusion of others for life. Next case is Corbett and Corbett. Okay, the principle is a person's sex is determined according to his or her birth. In this case, the parties had gone through a marriage ceremony. At that time, the petitioner knew that the respondent had been registered at birth as a male and had 3 years earlier undergone a sex change operation and had since lived as a woman. They lived together in matrimony for only 14 days. The petitioner filed a petition that the marriage was null and void because the respondent was a person of male sex. The court held that the respondent was not a woman for the purpose of the marriage but was a biological male and had been so since birth. The marriage was held to be void. It is to be noted that in case that knowledge of the fact that the marriage is a void marriage by one or both parties to the marriage is not a bar to the petition of a void marriage. Now we go to Lim Ying and Hyok Kian Ming Eric's case. The marriage took place in 1990 under the Women's Charter, which is similar to Section 69D of the LRA, as it requires that the parties to the marriage must be respectively male and female. The petitioner wife discovered after the marriage that the respondent was born a female and had undergone a sex change operation in 1987. Repeated attempts to consummate the marriage had failed. She filed for a divorce and asked for a declaration that there had never been a marriage between her and the respondent because the respondent was biologically a female. The court held that the fact that the identity card and the birth certificate have the respondent's sex as male and female respectively did not require the court to hold that a valid marriage had been solemnized between a man and a woman. Reassignment surgery does not result in the acquisition of all the biological characteristics of other sex. The next ground is ground under Section 22, subsection 4. Under this section, every marriage purported to be solemnized in Malaysia shall be void unless a certificate for marriage or a license has been issued by the registrar or chief minister, or a statutory declaration under subsection 3 has been delivered to the registrar or assistant registrar, as the case may be. Okay, we are finished with void marriage. Now, move on to the voidable marriages. A voidable marriage is a valid marriage unless the court declares otherwise. Only the parties to the marriage can take the proceedings to annul the marriage. Unless a decree is obtained, the marriage remains in force. Okay, the grounds for voidable marriages stated under Section 70. Okay, Section 70 of the LRA provides 6 grounds on which a marriage may be voidable. The marriage must be one which took place after 1st March 1982. However, Section 71, Subsection 2 of the LRA provides that a petitioner can only bring the case if the court is satisfied that at the time of the marriage, the petitioner was ignorant of the fact. The grounds for voidable marriages are The first one is no consummation due to incapacity. You can refer to section 70A, that the marriage has not been consummated owing to the incapacity of either party to consummate it. This based on the very basic idea of marriage, i.e. to have sexual intercourse. Marriage is not regarded as consummated until the parties have become one flesh by sexual intercourse. In the case of D and A, so the issue is regarding what is consummation. In order to amount to consummation, the intercourse must, in the words of Dr. Lushington, ordinary and complete and not partial and imperfect. There would be no consummation if the husband did not achieve full penetration in the normal sense. Then we go to Baxter and Baxter's case. The principle in this case is although the husband used contraceptive sheath, the marriage was considered to have been consummated. In this case, the wife did not allow the husband to have sexual intercourse with her unless he uses contraceptive sheath. The husband applied for nullity of marriage. The court in this case overruled the decision in Cowen and held that the marriage has been consummated irrespective of the husband's use of the sheath. Next case is L and L. The principle laid down in this case is inability to consummate, maybe due to psychological causes, and may either general or only with the particular causes, and may either general or only with the particular spouse. After 3 years of marriage, the evidence showed that the wife was still a virgin. The husband could consummate the marriage with another woman, but was incapable to consummate the marriage with his wife. The court granted a decree of nullity of the marriage to the wife. However, a rational decision not to permit intercourse is insufficient, and there must be some element of psychological or sexual aversion. In this regard, Kaminsky LJ said in the case of Singh and Singh, the petitioner, a 17-year-old Sikh girl, reluctantly went through a marriage ceremony arranged by her parents with a man she had never previously met. She never submitted to the physical embraces of the husband because it does not appear that she saw him again. Again, having taken the view that she did not want to be married to him, it is understandable that she did not want to have sexual intercourse with him. But that seems to be a very long way from an invincible repugnance. Next ground is no consummation due to willful refusal to consummate. It is stated under section 70B of the LRA. The marriage has not been consummated owing to the willful refusal of the respondent to consummate it. Willful refusal here means without just cause. Therefore, if the respondent can show a just cause for his or her refusal to consummate the marriage, the court will dismiss the petition. We refer to Kaur and Singh's case. This case was following Jodla and Jodla. Okay, the parties who were both Sikhs married in a registrar office on the understanding that they should not cohabit until they had gone through a religious ceremony in a Sikh temple. The court held in the circumstances the husband's refusal without excuse to make arrangements for such ceremony amounted to willful refusal to consummate the marriage. Okay, Jodla and Jodla. According to Hazen J, for there to be a willful refusal, there must be a refusal to consummate without just excuse. It therefore follows that a petition based on willful refusal must be dismissed if the respondent can show a just excuse for the refusal to consummate. Thus, if the parties have agreed that a civil marriage shall be followed by a religious ceremony, it is a just excuse for refusing to consummate the marriage on the ground that the religious ceremony has not taken place. The parties, who were Roman Catholics, married at a registry office but agreed that they would have a church ceremony before the marriage could be consummated. The wife made several requests to the husband to proceed with the church ceremony, but the husband refused. It was held that the wife would be granted a decree of nullity because the willful refusal to consummate the marriage was the husband's, as he had failed to arrange for a church ceremony. Such willful refusal on the part of the husband would have been just cause for the wife, having regard to their faith, to have refused intercourse if it had ever been requested. Now we go to the next case, Rati and Shanmugan. The principle in this case is where the parties have agreed that a civil marriage will be followed by a religious ceremony. It is a just excuse for refusing to consummate the marriage if one party refuses to undergo a religious ceremony. The parties are Hindus and they registered their marriage at the Registry of Marriage at Ipoh. They agreed not to consummate their marriage until a formal Hindu ceremony was held. The husband delayed the ceremony and told her that he does not wish to proceed with the marriage. The wife was successful in applying for nullity of marriage. The next case is Yong Fui Fin and Lim Tau Siu. The petitioner petitioned for a decree of nullity of marriage under the Law Reform Marriage and Divorce Act 1976. The petitioner, who is ordinarily domiciled in Malaysia, was lawfully married to the respondent on 5th May 1995 at the Registry of Civil Marriages, Malacca Tengah, Malacca. The facts as contained in the statement to the petition are: at the time of the registration of the marriage, it was mutually agreed that both parties would continue to live separately until a wedding ceremony under Chinese customary rites was celebrated at a later date. Due to unforeseen circumstances, both parties did not go through the customary marriage. The marriage was never consummated and the petitioner and the respondent have never cohabited. In this case, the court held that it is for the petitioner to prove that the incapacity exists. The petitioner before me did not disclose any evidence of incapacity of the parties to consummate the marriage in the light of the law adverted to. The available evidence only indicates that there was no consummation of the marriage due to unforeseen circumstances. That on its own does not bring the non-consummation within the ambit of Section 70A of the LRA. The petitioner had not shown that there was willful refusal to consummate the marriage. The available evidence only disclosed that the marriage was not consummated as both parties did not go through the customary marriage due to unforeseen circumstances. This was insufficient to establish that the marriage was not consummated without just excuse. That is to say that there was willful refusal by the respondent pursuant to Section 70B of the LRA.